the idea is that that the official response from the system could bring from one way to a kind of labelization of the child. So less answer could be better for mainly primary offenders. To avoid any secondary deviance. This is an interesting model which has been certainly more developed perhaps in Scotland, where there was a strong focus and still a strong focus on diversionary measures, for instance. Then, of course, you have, and we started to speak a little bit about that before, the restorative justice model, which is based on a totally different approach, solution focused, as I say, where the offender, the victim, the citizen, and in a way the state are exactly at the same level, and the focus is on finding a solution between the different parts. As you can imagine, and as you certainly know, New Zealand is extremely interested to study on this, Canada as well. And finally, the neo-correctionalist model, which is much more focused on punishment, and it's a kind of more pushy justice model, which is again could be in several Latin American countries where we went through different policies of mano dura, which means strong hand, with or tough on crime with kids. But of course, that will be totally foolish of me to try to convince you that countries are just following one of those models. And as you can imagine, the situation is much more complicated, and you can have a country following different approaches. But this is an interesting typology which gives you perhaps the philosophy of the justice system. So now going to today, what is happening? So that, you know, we were on a situation where we had 27 or more, 28 justice system, and perhaps now we're going to a situation where we'll have much more harmonization or homogeneity between the different justice systems, mainly due to regional guidelines from the Council of Europe and EU directive. So the most recent directive is the Directive on Procedural Safeguard for Children Accused and suspected of crime. And with that, just before that, I wanted to come back a little bit to the past of European text and recommendation. And what I think is interesting, if you go back to one of the first texts, of course, from the Council of Europe. The Council of Europe always been very active in terms of human rights and justice. One of the first texts we had on juvenile justice or child justice was a 2003 recommendation of the Council of Europe of different ways of dealing with juvenile crime, juvenile delinquency. And you can see that the beginning of the history of child justice at regional level start from the perspective of crime prevention, of juvenile crime prevention. And most of the texts that you have at the Council of Europe level or at the Economic and Social European Committee, most of the recommendations are focusing on crime prevention. While later on, to end up with the accumulating aspect of it with the EU directive, the focus went more on the child right approach, which is very interesting. And I think it might be due to the fact that both institutions, regional institutions, the Council of Europe and the European Commission decided to create a specific department on children's rights in charge of all policies regarding children, including justice. So now we are at the culminating part of this process. The EU directive was adopted already 4 years ago in 2016, And the states, member states, had the obligation to translate the EU directive into national law by 2019. Again, you're all very familiar with EU rules and law, but I want to remind to everybody that this is strictly binding document. A directive is strictly binding, so it is not a recommendation, and it's not from any institution that the Council of European Ministers. So that is extremely powerful document, which is of course binding, as I say, and this way it imposed the basis regarding to international standards, the UN Convention of the Rights of the Child, the different soft law that we heard before from our colleague, just introducing the topic of today, and which is important as well, the specific action of the Council of Europe, in particular the child-friendly justice guidelines. So two big elements that I wanted to recall here and that are very clear on the directive. The first one is concerning the Article 37 of the UNCRC, which say that the deprivation of liberty may only be used as last resort and for the shorter period of time, which you will see on this directive bring a lot of interest regarding to alternative measures. And then the second element is, which should be the aim of every child justice system. The focus is on the reintegration of the child into the society. And for that, you have, of course, to take into account the young age, the lack of full maturity, the lesser culpability than adult, and the human dignity. A recent element is certainly the general comment number 24 of the Committee of the Rights of the Child, which come back to the definition of the minimum age of criminal responsibility. That could be of interest for all of you, as well as the committee recommend that the minimum age now should be 14 and not 12, as it was the case before. And this is, of course, something that the directive show interest about. As I say, the directive is focusing mainly on international texts, but give a lot of importance to regional documents, just like I say, the child-friendly justice guidelines. And what is important there on the child-friendly justice guidelines is certainly one of the first documents focusing mainly on the place and the voice of the child in justice matters at all stages of the procedure. So the child-friendly guidelines, if we should translate it into two basic rights for children, this is certainly the right to be informed and the right to be heard. And the directive is giving a lot of importance to all of that. Yeah, so basically, the objective of the directive is to be that the recommendations are to give a comprehensive protection, of children at all stages of the criminal proceeding. And as well to focus mainly on this difficult concept to interpret, which is a child's best interest, but it should be the primary consideration. Concerning the scope of the directive, I think there is one very interesting element, which could be an element of discussion among us after. The first one is the fact that the directive is clearly focusing only on a criminal proceeding. So that means that it does not apply to system where the child justice system is not considered as a criminal justice system, but a kind of protective, corrective system. And if I'm not wrong, this is the case, for instance, for Poland. So the directive does not apply. But I knew that there was some element of negotiation, and if there is some colleagues there from Poland, will be very interesting to understand a little bit more or if the directive is going to be in a way respected or applied or not. The other element is clearly about the age. The directive applied to children under 18, which of course is true concerning the age when the offense was committed. The directive doesn't say that it doesn't apply for young adult who has committed the crime before the age of 18, but do not as a specific recommendation for young adult. The element which is based on the child-friendly justice guidelines is certainly what I say, the effective participation of the child. This is certainly one of the most important parts of this directive. And that is clearly bringing here for us several elements, such as the right to information. Children, parents should be informed of the different aspects of the proceeding, should understand well the consequences of the act, the consequences of the process. There is a strong element which was actually a big negotiation between member states. I remember when I was following the negotiation around the directive at that time, it's about the legal aid and the access to a lawyer, which the directive stipulates that there is a need for mandatory assistance for children and legal assistance. And then finally, there is a very interesting focus on individual assessment to focus the answer that is brought to by the child justice system to the specific needs of each children. Concerning alternative measures, there is a lot of discretion according to member states, of course, but there is certainly an obligation to consider non-custodial measures as a primary solution rather than deprivation of liberty. Then on specific safeguards, another element which is very interesting for several countries that are certainly present here is the fact that the focus should be on the separation between children and adults, which is clear as well in international standards. But there is an interesting element in the directive concerning young adults. So in particular, those who have been convicted before 18 and are following their measures after 18. The other element of safeguards is certainly to ensure that children deprived of liberty have access to education and training, all different kind of training, right to visit to family, etc., as hopefully it is already the case in many countries. In other safeguards, and there will be a lot to bring, so that's something that we could have a specific section only on the directive. An important element is the promotion of the use of audiovisual recording, in particular during the questioning with the police when the child enters in contact with the police as a first step, to avoid re-victimization of the child, to avoid repetition of the testimony, for instance. And then the protection of privacy is extremely important as well. And something which is today very interesting and might be an element of discussion among us after, this is the importance of presence of court, a court hearing, which have been very difficult recently with the COVID. And we've been pushing in a way for using alternative mechanisms such as video conferencing, etc. And there is a lot to say there that will be very interesting to exchange with you about that. And then, of course, a big part of it is the focus on training for professionals. So that was very briefly what is going to be our justice system. in the 27 justice system that we have in Europe, most of those recommendations are already into force, but not all of them at the same time. So the directive is certainly interesting to give some coherence to our different justice system. Just a brief question for the organizer. Do I still have 1 or 2 minutes, or is that too late?
No, you have enough time, Cédric. You can proceed.
Excellent, excellent. Anyway, I will try to be brief on that as well, as that will be interesting to open the floor and have a question. Some element that I wanted to bring to you, it's concerning the resilience of child justice system, and in particular what happened in the last few months, mainly with the first wave of the pandemic, of the COVID-19 pandemic. So we studied with a group of organization on FIRST. That was the first pandemic I lived in my life, at least. I was not there during the Spanish flu. We tried to figure what could be the best recommendation for the justice system in charge of children. And we decided to develop this set of recommendations on accelerate release of children from detention in time of pandemic. That document that you can find online, of course. We found that in Europe, and this document is worldwide, so you will have information about Latin America, about North America, about Asia, about Africa, but MENA region, and this is very interesting to see how the approach was so different country by country in Europe, but as well in a different region. At European level, we saw several elements. We saw first that there was some position taken by the Department of Children's Rights of the European Commission, who defined some action to take into account for children in contact with the justice system during the pandemic. Of course, the main recommendation was to respect the safety measures that as they were developed by the World Health Organization. But I'm sure that you would have experienced the same thing than us during this study. Most of the recommendations of WHO, even if they were excellent, they might have been very difficult to implement in the different detention facilities. Why? Because we still have facilities which are overcrowded. We still have facilities where the access to basic health is difficult. And I'm not speaking only about other regions of the world. This is the case as well in Europe. Interestingly, the European Parliament, they formed an intergroup on children's rights, and they decided to develop some recommendation for member states concerning COVID-19 and children. And of course, the first elements, as you all know, was if you release children from measures of deprivation of liberty, there is certainly an important element to take into account, which is the relation within the family during the lockdown, and the increase of domestic violence. This was true from the gender perspective, but as well in a different age group as well. And then the other element for the countries who decided to release as much as possible the kids from the detention was to ensure that there is at least some follow-up within the community. So we saw, and again, I will have in the group here certainly people from all of those countries who will have elements to tell about each country. So this is summarized in one sentence. So it doesn't bring all the complexity of the national answers, but it's very interesting. This is just some example where you can see that each country in the emergency, in the panic, decided to adopt a very huge range of measures to answer to the pandemic. You see, for instance, that in some countries they decided to increase the separation of between the inmates, which could have been seen as a, double victimization. No? They are already deprived of liberty, and then they are cut from the exterior and they cut from the other prisoners or detainees. So it's a kind of double victimization in a way, a double confinement. In other countries, we saw that there was a policies of or strategy to release children from detention, mainly for those who were at a pre-trial stage. And states decided to try to find alternative to pre-trial detention, or at the end of the measures to try to empty as much as possible the detention facilities. So that was some plan of early release that have been developed in different countries in Europe. And then, of course, there was an important part regarding to health and health measures and the hygiene measures in the different centers that are that been suffering from the pandemic. As a basis of those recommendations, and you know, I will not have time to enter in this policy and practice brief, but I encourage you to have a look. There was very interesting example of practices from all over the world, and how to see how the COVID impacted on the justice system and mainly on the deprivation of liberty. But we decided to develop a set of 3 operational guidelines for professionals. Here they are. The first one is for security forces, for police in particular, where we developed guidelines to encourage, where it's possible, diversionary mechanism at police level to avoid as much as possible formal answer from the justice system and the contact of the child with the formal justice system. Of course, for different reasons, for reasons related to the pandemic, and for the reason that we saw before in this James Dignan typology, not to avoid the labelization of the child who come in contact with the justice system. There was more recommendation on as well with this operational guideline for professional on social workforce, where we try to figure out how could we support professionals to continue working, working on the reintegration of children in spite of the adverse environment. So, or to use new technologies, in particular in the follow-up of the situation, or in the follow-up of each children. And I encourage you to read here the newsletter of the European Forum on Restorative Justice, which is about restorative justice practices in time of COVID, and all different countries been trying, or programs been trying to implement restorative justice with new mechanism, new technology. And the last one was about recommendation for legal professional in with a tiny focus on lawyers, on how to change as well the information given and the measures asked for the child in order to improve the solution and foster the release of children in conflict with the law. So very briefly, and this is more or less I say, we had a very interesting exchange with experts on the use of a new form of communication in the justice system. That, for instance, if you are interested, I will be very happy if the organizer can share my email address, but we are now working on some guidelines in terms of use of new on digital tools in the child justice system, and how the COVID-19 had changed our perspective of it. And I mean, one of the elements there is to try to avoid to enter in a world where everything will be digital, because now we started and we see that it's very effective, but human contact is important. Well, we believe in that. And then and yes, I think I will finish with that, with a few recommendations concerning the next waves. I think we learned a lot in the past wave of confinement, lockdown, and how to deal with the pandemic. But what I found interesting at my humble level with the pandemic and the consequences of the pandemic into the justice system is that our justice system is able to adapt at the end more or less quickly. But we always have this image of having something very, very slow, our elephant, we call it sometimes. But when it's needed, the justice system is able to react quite quickly. Another element that we found very interesting doing this research is the concept of disengorgement. It's possible to reduce the number of people in detention. And actually that should be encouraged. And then that will bring me to creating a bridge between childhood and adulthood. But I think that should be disengagement of detention should be considered for young people and adults as well. And I will finish with that. Thank you very much. And I'm very happy to answer to any question. Thanks.
Thank you very much, Cédric, for your very interesting presentation. It looks like participants have been listening so carefully. There was no time to write a question in the chat. Yeah, so it's very interesting also to hear your evaluations about COVID and the developments that have happened as a reaction to that in the prison and probation services. And of course, a lot of what you mentioned here, which is focusing on children and juveniles, is true for the whole population of detainees. And I agree that there has been, what we saw from our side was that there's a really quick reaction on the situation, on the pandemic. And I thought it was kind of really astonishing to see that next to, I mean, people were busy before the pandemic, and then suddenly something comes up and you have to react and you have to change a lot of systems. And it will definitely be very, very interesting to evaluate everything that has been implemented now or changed, like you mentioned, the use of new media, the court hearings, which we indeed also heard that a lot of those court hearings now countries change into video hearings. It's also more accepted by the courts. So use of alternative measures, all of this has been happening, you could say against all odds, because sometimes prison services were still kind of hesitating to implement some of these measures, and now because there was a pressure, it was done, and it probably turns out to be not as bad as it was expected before. But as you say, a thorough evaluation will be needed after, when we have hopefully left all of this behind us in a couple of months, to see what are the ups and downs of all of this, and the consequences and how to deal with it. So that will be very interesting, because like you said, I mean, the increase of video visits is a very positive development, has been received very positively, but there are some concerns about, will it just be an add-on or will it be a replacement? And yeah, what about human contact and etc. So yeah, very, very interesting. One question is, you mentioned a couple of documents that you advised us. Can I ask you to maybe share that with us after the link to these documents, so we can share it with the participants as well, so they have access to them? That would be really nice. And I see now questions coming in, so let me look at this. There's a question. Cédric, as you said, the directive is a key and powerful document. Do you know if there are ways of following the implementation of this directive in different EU countries? And in addition to that, a question came up also on my mind about EU directive, because it is a binding document. What kind of problems have you seen that countries had with what are the main challenges for countries to implement the directive?
Yeah, so it's a very good question. So at the European Commission, there is a specific team following the directive. They've been in charge of the production of the first directive. And actually, perhaps one day we will read in our school manual the evolution when the directive was presented by the European Commission, and then when it was transformed by our member states, and then the result we had. But I still think that is a good document that we have, and actually it's bring at least a common understanding between our countries. So there is, as I say, you know, June 2019, that was a date that the directive should be implemented at national level. I can tell you that in 2019, in June, almost no countries has implemented the directive. And so they've been working quite hard, as far as I know, in most countries on the second half of 2018. But again, the pandemic didn't help, and was quite a good excuse for everybody to get a little bit late with our homework. So I think basically what is happening at the moment at the level of the Commission, there is no vocabulary related to sanction, by the European Commission about the good or bad implementation of the directive, because I think the process is still ongoing. So that's something that from my point of view, it's a good opportunity as well for us as professional and as a civil society, perhaps to bring some support to our decision maker on the implementation of the directive. And what will be important, I think the most important part of it will be what will be after, because we will have to train a lot of professionals. I remember being in a conference of judges and magistrates, where one of the judges at national level, and I will not say the country, told me that the directive is so slow. And I was thinking, wow, if a judge doesn't know that, you know, we will have a lot of people to train about that. So I think that the directive, to answer your question now, Kristen, the directive is certainly important for me to bring this common understanding between countries, which certainly will bring a lot of result in terms of transnational cooperation. I can imagine that the justice system were evolving, you know, step by step and slowly, sometimes in the right direction. But the collaboration between the justice system and in particular the what do you call that, the co-recognition of the justice system by member states was still something that has been to be much more developed, and I'm pretty sure that the directive will help with that.
Okay, thank you very much, Cédric. The questions are coming in now. I have one here where it's asked, what would be your advice to reduce stress created with COVID-19 to young offenders who are in prison, so they could be more prepared and not afraid to be released from imprisonment?
Yeah, you know, I think that was the same. this is a general recommendation for everything related to deprivation of liberty. And I say that because I think this is exactly the same pattern for young people and old people. The fight to cut citizens, children, adults, elderly from the rest of the society is very dangerous in terms of mental health. And we heard about that many times in the newspaper, in discussing with our colleagues, etc. The increase of crisis, mental health crisis between children in detention, or again, I make the parallel with elderly in a retirement house as well. That's something to take into consideration, that even if there is the risk of the pandemic, you should keep the contact with the outside world. And that actually should be a recommendation even without the pandemic. You can't really imagine that a detention center will manage its objective of reintegration if the child is just locked down during, I don't know, several years and then just released after without any preparation. The preparation should be making the sanction more open, more contact with the exterior, and making, in a way, prison a little bit more connected with the society.
Yes, thank you. Yeah, that's probably true, that a lot of these things are true for normal life as well, but maybe now they are pointed out a little bit more, like how necessary certain aspects are during the detention. I have another question here where they are asking if after this isolation time that we all have had to face, and therefore after experiencing the effects of liberty deprivation, less social interaction, do you think that this will impact on how the penal execution system will react on to primary offenders? And where do you think that the penal system is heading to? So that's a big question.
Listen, this is a very good question. So I'm, in the context of this global initiative on justice with children, we started to work on a group of experts for the future of justice, to try with a few futurologists, some criminologists, some children rights experts, to imagine exactly that for the climate, the different scenarios for the justice system. I'm kind of positive person, so of course I will believe that we're going to learn and find a solution for the justice system for children, make it more child-friendly as recommended by the Council of Europe, making more open as recommended by the UN Global Study on Children Deprived of Liberty, more open on the society. And then, of course, I hope that all those mechanisms we've been pushing through at international or regional level are now getting to the professionals through trainings, through public awareness, etc. I have the feeling that, I remember a very personal experience. I remember being member of the European Society of Criminology in Krakow in 2005. There was only one workshop on expert on juvenile crime. And now if you attend that, it's almost a majority. And so there is more and more interest. So I do believe that that will certainly go on the right direction, which is focusing mainly on community-based sanction rather than deprivation of liberty.
Yes, thank you. And we will hear more about that also, I think, in our next presentations today. Cédric, there is no more time for questions. There are no more questions. So thank you very much again for your presentation and for responding to the questions. Thanks to the participants for their questions. And if I can ask you to stop sharing the screen, then we can move on to the next